The government, in their complaint, may have used the wrong statute, at least in my opinion. After I have done some additional research, I have some more thoughts on this Hannah Dugan case. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. Now, I don't want anybody to think that I think that this is going to be dismissed immediately or that there's somehow not going to be a prosecution, because I do think the government is committed to going forward with this prosecution. But the statute that was used, the 1505 and 1071, both of those statutes might not be the most effective statute to use in this situation. And in addition to that, particularly 1505, there are problems in terms of how things are interpreted. Up front, I want to point out that this was called to my attention by one of my subscribers, and he raised an issue, and I thought, I need to look at that. And indeed, I think I may have gone past this, not recognized the issues that were inherent in how they charged her. And so I want to apologize up front for not getting this in the first video. But when you make a mistake, you better own it. And that's what I'm doing. So let me go forward now with some additional analysis that should have been in the last video, although it probably would have made that video too long. So let me start at the top by saying that normally in a statute where you use terms of art, they are defined. If you, for example, want to say something about the United States, usually the statute will define the United States. And of course, 18 USC does define the United States for purposes of the kinds of things that are included in Chapter 18, any of the crimes in Chapter 18. On the one hand, we're fortunate that in 18 USC section 1515, they define the term corruptly. Unfortunately, they don't define it very well, which we'll show in a moment. And as a result, there have been some other definitions of the word corruptly that have found their way into the lexicon of law, and that has created some confusion, particularly in the past. So let's look first at the text of section 1505, the one that they charged Judge Dugan with. It says, whoever corruptly or by threats or force, neither of those are in play here, or by any threatening letter, again, not in play here, or communication influences, obstructs, or impedes or endeavors to influence, obstruct, or impede the due and proper administration of the law under which any pending proceeding is being had before any department or agency of the United States, or the due and proper exercise of the power of inquiry under the rules of the House and Senate. So that's what the statute actually says. In order to understand the statute, we have to know a couple of things. First of all, what does corruptly mean? And second of all, what does department or agency of the United States mean? 18 U.S. Code Section 6, Department and Agency Defined, gives us the answer to what department or agency means. Department means one of the executive departments enumerated in Section 1 of Title V, unless the context shows that such term was intended to describe the executive, legislative, or judicial branches of the government. So here's what Title V, Section 1 says. Section 101 says the executive departments include the Department of Homeland Security and, of course, both ICE, Immigrations and Customs Enforcement, as well as Customs and Border Protection, CBP, are both agencies of the executive department of the Department of Homeland Security. And so we meet the definition of an agency. We know that that's there based on 5 USC Section 101. The question then becomes, what is a corrupt action? Fortunately, we have an answer to that in Section 1515. It says, as used in Section 1505, the term corruptly means acting with an improper purpose, personally or by influencing another, including making false or misleading statement or withholding, concealing, altering, or destroying a document or other information. So because we have these other code sections, the cases tend to come down mostly on the 1512 statute, which is another of the official proceeding statutes. And in Fisher versus US, which was the case that involved the January 6 defendants, the government must establish the defendant impaired the availability or integrity for use in an official proceeding of records, documents, objects, or other things to be used in official proceedings or attempted to do so. So it narrowly construed the reach of 1512. Before that, in Arthur Anderson versus the US, only persons conscious of wrongdoing can be said to knowingly corruptly persuade, and limiting criminality to persuaders conscious of their wrongdoing sensibly allows the statute to reach only those with the level of culpability usually required to impose criminal liability. And it cites to Aguiar. And Aguiar says the defendant's conduct must have a relationship in time, causation, or logic with the proceeding, and the defendant must act in contemplation of a particular official proceeding. So, given that these statutes are all sort of tied together and that their definitions are being narrowly circumscribed by federal courts, the the government may have a problem with charging under 1505. Here's the problem for the government's case. When you say that someone acts with an improper purpose, that is a vague term, improper purpose, and the fact that there is no requirement that she act knowingly. So that creates a culpability problem in terms of imposing liability for what could be innocent conduct. Now, I know most people are not going to appreciate this, but it's possible that she could come into court and say, I was acting with a completely proper purpose. I was trying to protect my jurisdiction, or I was trying to see my case through to the end, or I wanted to make sure that the victims got, justice, and they couldn't do that if they whisked this guy off to Argentina or someplace. She might do that. She might not. It's hard to say. She doesn't have to say anything. The problem is that the term improper purpose is vague enough that I can see a vagueness challenge being mounted to this statute and seeing it be successful. It only takes one district court judge or a pair of appellate judges to reach that conclusion. And certainly, if I were representing this woman, that's what I would urge. I would urge that the definition is so ambiguous that you have no way to know how to guide your conduct. Who decides what's an improper purpose? Is it the person who is acting with this improper purpose? Do they have to know that their purpose is improper? There are so many that this is just simply too vague. In other words, this is not really a problem with the FBI's investigation. It's not a problem with charging the conduct, because the conduct does appear to be illegal under other code sections as well. The problem is that that particular statute, 1505, and the definition of it are just impermissibly vague. Now let's take a look at the code section that I think might have been a better way to go in terms of charging Judge Dugan in this case. That statute criminalizes knowing or in reckless disregard of the fact that an alien has come to, entered into, or remains in the United States in violation of law, conceals, harbors, or shields from detection, or attempts to conceal, harbor, or shield from detection, such alien in any place, including any building or any means of transportation. Obviously, a courthouse is any building. So 1324 would probably have been the better statute to charge her under. But keep in mind, the issuance of a complaint is not necessarily the last word. It is basically an allegation by the U.S. attorney that a crime has been committed, and you ask for a warrant, you get the warrant. There has to be some other procedure to determine if there was probable cause. But what usually happens, usually even before the arrest, although for some reason they felt it was necessary to rush this. Usually, what happens is they impanel a grand jury and they present this case to the grand jury. The grand jury has to determine if there's probable cause to find that someone has violated a particular statute. Now, if the grand jury indicts on 1505 and 1071 and 1324, it's called it's an indictment, and those are the charges that will be brought. So the government can change horses in the middle of the stream here if it wants to, if it decides that it needs to. There are several commentators out there who think that everything's just fine. There are several who think that it's not an appropriate charge to use, the 1505. I tend to agree that 1505 is not the best choice. Now, will it fit? I don't know. I would think it would be very subject to being overturned on appeal. But at the bottom, it's really going to be up to a federal judge and the appellate courts in the federal system to determine whether this is something that should be a conviction or not. Honesty and integrity require that when I feel like I haven't done a good job to begin with, I come here and I tell you that, and I lay out what I did wrong, and I lay out what I believe the actual case is. And so I don't want to give anybody the impression that this case against this judge is a slam dunk, because it's not. Will she get convicted? I don't know. The law is in way too much of a state of flux at this point to know whether or not it will even withstand a motion to dismiss at this stage. Keep in mind that a motion to dismiss, if it was filed and if it was granted, would not be a final determination on the merits, because the U.S. attorney could come back and charge her under one of these other statutes. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.